My name is Muhammad Nifan bin Nordin and my metric number is 294255. So based on question 1, what were the term and condition which agreed by both party in the respect of the guarantee document? So the answer is, in the legal case involving Bank Pembangunan Malaysia Berhad and the defendant, Ibu Kota Realty Sdn Berhad and Loh Cheng Hong, the closure with the guarantee agreement play a critical role in defending a liability of all parties involved, particularly in the guarantor. So the first main point is guarantor as a principal debtor. So the guarantor terms multate that the guarantor are considered principal debtor, meaning they are equal responsibility for the loan obligation as the primary borrower. This clause ensures that the guarantor are not merely secondary or initially to the borrower, but as stand direct party liable for repayment. So next point is about unconditional liability despite change to loan term. So a critical clause in the guarantee is that the guarantor obligation are unaffected by any amendment to the loan agreement. This provision ensures that even if the term of the loan change after the guarantee is signed, the guarantor remains fully liability for the debt, regardless of the knowledge or agreement to those change. So next is about direct recovery from guarantor. So the guarantor allows the bank directly invoke the guarantor liability without the necessity of resorting to other security of guarantor. This clause facilitates the bank's ability to recover the debt swiftly and efficiently, offering a stimulant part of enforcement. So the next point is bank certificate of account. In the inclusion of a clause stating the bank certificate of account will be considered conclusive evidence of the amount due from the borrower is a strong legal safeguard. So last but not least is about supplementary to other remedies. So the guarantor is described as being supplementary to other legal remedies available to the bank. This means that the guarantor is not the real resource but can be used alongside other legal strategy for the debt recovery. So that's all for me. Thank you.
Assalamualaikum, my name is Noaina Farina binti Muhammad Salmi and my metric number is 288163. Today, I will explain the main issues raised by the defendants in this case. There are 4 points: failure to show calculations and the ECOF rate, lack of updates on ECOF rate changes, liability sharing, and incomplete disposal of securities. Let's go through them one by one. The first issue is about transparency. The defendants say the plaintiff did not provide details on how the amounts were calculated. This includes the ECOF rate, which is important for calculating interest. Without these details, the defendants felt the claim was unclear and unfair. The second issue is about the ECOF rate changes. The defendants say they were not told about changes to the rate. This rate affects how much they owe as guarantor. They feel it was unfair to be held responsible for something they didn't know about or agree to. The third issue is about sharing responsibility. The defendants argue that the plaintiff should first use other securities to reduce the debt. Only then should the defendants be asked to pay their share. This would make their liability fairer. The last issue is about the borrower's assets. The defendants say the plaintiff had not fully sold this asset to recover the debt. They argue that until this was done, the plaintiff should not demand payment from them as guarantor. In summary, the defendants are asking for fairness and proper procedures. They want clear calculation, updates on rate changes, fair sharing of liability, and all securities to be sold first. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Fatira binti Rasdi, metric number 286464. I will continue the presentation with the question number 3. Okay, today I will discuss about the discussion whether a plaintiff have the right to enforce a guarantee provided by the defendants when a loan facility is in the default. This topic is based on a legal case involving Bank Pembangunan Malaysia Berhad and the enforcement of a loan guarantee. Okay, the first discussion for this case is plaintiff's right to enforce the guarantee. The plaintiff is in this case is entitled to enforce the guarantee because the loan facility is in default. The court has found that the defendants had signed joint and several guarantee has agreement in favor of the plaintiff as security for the loans. Since the borrower failed to make a loan's repayment, the plaintiff had issued a notice of demand to the defendants and a notice of termination requiring full payment of the outstanding dispute liability under the guarantee, but only challenged the amount claimed by the plaintiff. However, the court has rejected their objection as they lack sufficient evidence to refute the plaintiff's claims. Okay, for the key legal point, the guarantee agreements clearly state that the defendants were principal debtor, not the sureties. This means that the plaintiff has the right to claim the debt directly from them without first pursuing other securities or legal proceedings against the borrowers. The court also ruled that the guarantee's terms were binding and the defendants had agreed not to contest variation in interest rate or other loan term. For the supporting evidence, the plaintiff provided a certified statement of account verifying the amount owed. Since there was no proof of any manifest error, the court accepted this statement as accurate. The court also notes that neither the borrower nor the defendants had challenged the demand notice at an early stage. This further reinforced the plaintiff's right to enforce the guarantee. For the conclusion, the court ruled in favor of the plaintiff and grants summary judgment because there were no triable issues. The case was primarily about the interpretation of contractual documents rather than dispute facts. Therefore, the plaintiff had no right to enforce the guarantee and recover the full amount from the defendants. Okay, that's all from me. Thank you.
So I'm going to continue with the question number 4. The question is, does the he defendants have a right to contempt plaintiff when the plaintiff failed to inform the defendants on the changes of rate which they claim that the changes were outside of their knowledge and consent? Give your opinion. So our answer for this question is the defendant has no right to against the plaintiff because he has no strong evidence regarding his claim, which is he has no knowledge or concern about the changes made by the plaintiff on the effective cost of fund rate, or also known as the ECOF rate. In this case, plaintiff write its notice dated 2nd September 2016 about he has already informed or state regarding the base lending or base financing rate, and the rate claimed on the defendant by the plaintiff is only 6.50% per annum and on the borrower is 6.75% per annum. The affidavit replied by the plaintiff on the statement of account also mentioned about the changes of the ECOF rate starting 1st September 2016 until 1 August 2020. In the security document, both also had already agreed or signed the agreement regarding on the right of the plaintiff to vary the ECOF rate. And based on the knowledge in the banking security, I can conclude that a guarantor should read or understand the agreement or take legal advice if needed, especially on the implication. A financial institution also have a right to take actions against the borrower or guarantor if all else action taken to take the repayment is failed. So for the question number 5, I'm going to pass it to the next presenter.
Hello everyone, now I would like to speak about the type of guarantees for Dependent 1 and Dependent 2 and their liability as principal debtors. Firstly, overview of guarantees and liability. The Defendant 1 and Defendant 2 executed joint and several guarantees in favor of Bank Pembangunan Malaysia Berhad to secure two distinct financial facilities. The first facility, a term loan, and the second facility, which included term loans and revolving credit. These guarantees were designed to hold dependent 1 and dependent 2 equally and independently responsible for the debt as principal debtors, not more sureties. Next is principal debtors versus sureties. As principal debtors, dependent 1 and dependent 2 were placed on the same level of obligation as the borrower. The designation meant the bank did not need as exhaust all remedies such as liquidating the borrower's assets or pursuing other securities before seeking repayment from the guarantors. This streamlined the recovery process, ensuring the bank could act swiftly in case of default. The legal framework emphasized the guarantor's full accountability for the loan repayment independent of the borrower's financial status or repayment capacity. Moreover, its key guarantee provisions. The guarantees included clauses that reinforced the bank's rights and protected its interests. For instance, changes to loan terms such as interest rate adjustments did not relieve the guarantors of their obligations, even if they were not notified of these changes. Additionally, the lender's certificate of indebtedness was deemed conclusive proof of the debt unless proven to be manifestly incorrect. The provision simplified legal proceedings, and as the bank was not required to present extensive evidence to validate the debt amount in court, enabling faster enforcement of the case. Therefore, the court rulings and liability enforcement, the court upheld the terms of the guarantees, underscoring their enforceability and the guarantor's clear liability. It ruled that the bank was not obligated to sell the borrower's assets to exhaust other securities before pursuing dependent 1 and dependent 2 for repayment. The defendants were unable to substantiate claims against the debt amount or argue procedural deficiencies, leading the court to accept the bank's certificate of indebtedness as valid. The decision reinforced the guarantee's effectiveness in securing the bank interest and enabled a swift resolution in favor of the bank. In a nutshell, the guarantees provided by Dependent 1 and Dependent 2 exemplify the importance of comprehensive legal agreements in credit risk management by designating the guarantors as principal debtors and including provisions that prioritize the bank's ability to enforce repayment. The guarantees ensured robust protection for the lender. The court's ruling highlighted the legal strength of these agreements, demonstrating their utility in safeguarding financial institutions' interests and facilitating efficient debt recovery. That's all from me. Thank you.